Today on Cornell Keynotes, we are looking at the relatively new phenomenon of universities having in-house legal counsel and what this means for legal professionals who are working in or aspire to work in the higher education space. Joining us as moderator is Jens Olin, who is the Alan R. Tessler Dean and Professor of Law at the Cornell Law School. His guest is Lou Gard, who is General Counsel at Hobart William Smith and also Adjunct Professor at Cornell Law and co-author of the book, All the Campus Lawyers, Litigation, Regulation, and the New Era of Higher Education. Jens and Lou discuss the key legal challenges facing higher education today and discuss what may be ahead in the near and long term for general counsels at universities. So check out the episode notes for info on the Master of Science in Legal Studies degree program at Cornell Law and a link to Lou Gard's book. And now, here's Jens Olin and Lou Gard.
Thanks so much. So Lou, thanks for being here and thanks for writing this great book. And thank you for teaching at Cornell Law School. And I'd love to have a great conversation with you about higher education. So, let's start off with a general question. What do you think are some of the key legal challenges facing higher education today?
Thanks, Jens. And yes, it is great to be here and to be speaking with you. I think, the last time you were peppering me with questions, I was a student in your criminal law class many, many years ago. So I don't know if I was more prepared then or now, so I'll let you be the judge after. You could email me my grade maybe, but this is a great topic. Me and my co-author Joyce Jacobson, we just love talking about this issue. The genesis for our book, to start to get at your question, was kind of funny. It was one of these typical occurrences that a general counsel might have with their college president. I walked in one day for my usual meeting, and I had a bulleted list of maybe 10 different issues to go work through with the president, and it ran the gamut from a pending piece of litigation to an employment issue to an athletics issue, an intellectual property issue, just a whole list. And at the end of our meeting, President Jacobson looked at me and she just kind of half joking goes, "This is just crazy. We should write a book." It was like one of those days where all these issues were out there. So that kind of, I took her a little bit too seriously, and then kind of building in some of the work that I had done as an adjunct down at the law school at Cornell with the higher ed law class, started to sketch out this idea. And really, so to get to your question, the first half of the book chronicles what all of these legal issues are facing colleges and universities, and really what we see as the acceleration of these issues over the past 10 to 15 years. So, we're talking about stuff that is both probably very well known to many folks, but then maybe more a little obscure and under the radar. But all of it has a very deep and profound impact, I think, on what we do in higher education. So we're thinking issues in the civil rights area, so such as Title IX, which I'm sure will be familiar to all listeners, Title VI, which was very much an issue on campuses last year, the Americans with Disabilities Act, Title VII obviously applies to private employers, and so that includes colleges and universities as well. So that's a whole chapter and treatment in the book. Free speech and expression issues on campuses have been kind of a festering area of intrigue and study. And so we treat that a little bit as well. And that, of course, overlaps in important ways with things like Title IX, Title VI, academic freedom. And then, we focus on the whole kind of panoply of issues facing the student experience and student life on campuses. So everything from, as I mentioned, athletics, legal issues to the variety of ways, Greek life, student mental health issues, and all these sort of risk areas that involve this student experience and student-facing interaction. So, that's a bucket of kind of three very broad but very prominent areas that I'm sure people have heard about. There's also issues related to admissions. Being a revenue driver for institutions is an important area to focus on. But obviously, the Students for Fair Admission decision received a lot of national attention, so that's probably very familiar to folks. And as a pressing issue, I think, going forward. We also look at governance issues and a variety of others. But that's kind of the for the most part, the playing field that we deal with in the book and that we think are the promising or the sort of most prominent pressing issues facing the sector.
Before we go any further, can you just briefly, explain what the difference is between Title VI and Title IX, since you mentioned those, phrases, and we hear a lot about them in the newspaper and or read a lot about it in the newspaper and on the radio, but it's a little bit of a technical distinction. Can you explain what those words actually mean, Title VI and Title IX?
Yeah, so Title IX is probably familiar to some extent, but is a broad prohibition on discrimination on the basis of sex, right? So Title IX bars discrimination on the basis of sex. That's kind of I think the simplest explanation. Title VI pertains to discrimination on the basis of race, color, and national origin. So prohibits discrimination based on those protected classes. And so each of those statutes have a regulatory infrastructure underneath them and guidance infrastructure that informs how colleges and universities comply with those mandates. And that, not to jump too far ahead in our conversation or to any of this, but I mean, that's sort of where the devil is in some of those details, so to speak, right? Because it's easy enough to say, thou shalt not discriminate on the basis of X, Y, or Z, but how that gets enforced and how that gets sussed out on campuses and in courts is really the sort of meat and potatoes, I think, of the story here.
That's great. Let's hear our first poll results.
Yeah, you bet. And thanks for the clarity on Title VI and IX, because 12% of our audience are lawyers working in higher ed. Not to say that the rest of the 88% isn't made up entirely of lawyers, but we don't know. But anyway, useful clarity. There you go. Those are the results. So back to you, Jens.
Yeah, that's great to know, because I think everyone is incredibly interested in the legal issues in higher education, but not everyone has the front row seat that you do, Lou. So it's great to have the rest of this conversation. So let's delve a little bit deeper of all of these, sort of legal issues that are facing higher education and that, you're dealing with directly as general counsel. How do you think they impact students, faculty, and to a certain extent, staff? And why should people in higher education today really care about the legal issues that you're dealing with running out of your office?
Yeah, I think the impact is pretty profound. Some people probably experience it a little more softly and subtly than others, but just to start with the anecdotal and maybe move into some data points. I mean, I think people have the sense that legal issues, regulatory issues, legislative fiats or interaction with higher education is sort of consuming more and more of the life we live on college campuses, which is really supposed to be about the life of the mind. And, we begin the book with a vignette about if you're a subscriber to like the Chronicle of Higher Ed or Inside Higher Ed or any of these publications, you probably get these morning emails where they summarize the news of the day. And it's impossible to open one of those without seeing minimally one issue that's a legal issue. But usually most of what they're publishing about is some type of a lawsuit, some type of a governance conflict, some new piece of legislation that's going to challenge, the ways in which colleges and universities are conducting their affairs. So I think it's pretty all-consuming, and certainly, the way in which folks perceive that and react to it is going to depend on their kind of station within the institution, right? I think on the faculty side, it feels a bit like, at least what I hear, is that some of these legal developments can perhaps be a distraction to what they see as as I mentioned, carrying out the work of the life of the mind, the core enterprise of higher education. I think that's a perspective I hear shared among faculty members, but certainly a very real concern that we all need to deal with. I think that particularly for faculty, it's hard to talk about the faculty perspective on some of these issues without considering academic freedom. And I think the ways in which some of these legal developments may be perceived as encroaching on academic freedom or interfering with academic freedom in some way. So I think that's a very real perspective. On the student side of things, I think, look, a lot of this stuff, especially in the tort area, I think really defines the ways in which institutions interact with their students a little bit differently, right? And so, one of the things we trace in the book is the evolution, this sort of tort law evolution from the early days of in loco parentis and institutions really having kind of the full ability to do whatever they want with extreme deference from courts to what commentators and scholars have called the bystander era of maybe like the 80s or early 90s, where courts were more like, look, they're over 18, they're adults, this is a really terrible thing that happened, but the college or university had nothing to do with it. We now live very much in a middle ground. We call it the caretaker era, where courts are more likely to find that institutions have some duty of care that falls on them, right? So institutions can't do nothing, but they also sort of can't be so overbearing that they're, controlling every aspect of the student's life. And so I think that from a student perspective, they probably feel a little bit more of that creep into their life. And, I think that could be very real. So, and then on the staff side of things, I think one of the very obvious things is that I do think you could attribute growth in staff headcount in various areas to various compliance or regulatory mandates, or minimally kind of the secondary or tertiary effects of that, needing more staff in student life, for example, or those sorts of areas. So I think it obviously depends on what your position is and a little bit kind of what your personal perspective is. But those, if I had to kind of broadly extract, I think those are the ways in which those groups are feeling some of these things on campus.
Yeah, so it's really interesting to hear you say that, because from my perspective as a university leader, I definitely experience, on a weekly or perhaps daily basis, the extraordinary responsibility and responsibility that universities are tasked with in terms of student life in a way that, certainly was not there 40, 50 years ago. But even compared with 25 years ago or 20 years ago, there were all sorts of situations where if something negative happened to someone who was a student, society or families wouldn't necessarily attribute a responsibility to the university to solve that issue in someone's life. But today there really is more of an expectation of that, and universities have to respond to that obligation, and it's a much more complicated landscape because of that. I wanted to ask you a question about all of these legal rules, legal principles, legal responsibilities. Is it always kind of clear cut, how they apply in a situation, or are you ever in a situation where you've got multiple legal rules, some of which are either in tension or collide with each other or interact in a kind of complicated way, and it's just not something as simple as, okay, here's the legal rule and it tells us exactly what we need to do, but it's more of a kind of collision of multiple legal norms or legal principles?
Yeah, no, for sure. I think most practitioners in the higher ed legal space really wish it was a little more sort of rules based and just direct and to the point. And I often tell folks that if you get an answer back from your lawyer and it seems very direct and easy and straightforward, you may want to think twice about that. For most of the stuff that we do in higher ed, obviously, some of these rules have very clear kind of guidelines, but a lot of it is fairly ambiguous. I mean, you can take, for example, what we started talking about at the top, Title IX and Title VI. I think normatively everyone can agree about kind of what that says on its face. But then when you get down into the case law and the regulatory material underneath that, and you start looking at a term like deliberate indifference and what constitutes deliberate indifference, what kind of conduct by an institution is deliberately indifferent enough such that you violated Title VI. That's highly fact specific, like really fact specific. And these fact patterns are kind of wild and all over the place. So those situations, I think, require obviously extremely refined judgment. But again, to skip ahead to some of this content, really are about values, I think, of the institution. So when you're kind of in this gray area, and when there may be possible pathways that all of which are defensible and meet the letter and spirit of the law, but there may be multiple pathways, I think it's wise for institutions to always be reverting back to what is our mission, what is our value set, and what is most aligned with that, because that's ultimately what you're going to have to defend at the end of the day, right? So, and you're going to want that to be sort of driving you and motivating your response.
That's very smart. And everyone needs to remember that a university is not a corporation. It's not a for-profit corporation. The goal of the university is not to maximize profit. It's to educate students, train students, and perform research. And that makes it a very special enterprise, and that implicates how it approaches some of these issues. So we've got a great question from Tara out there. She wants to know what tort means and wants an explanation of that for non-lawyers. I can jump in and say that a tort is usually a lawsuit that's filed where there's no contract between the parties. So you can have a contract, you can have a lawsuit, which is a contractual dispute governed by a contract, but you can also have a legal dispute between two parties where there's no contract, either written or unwritten. And that would be governed by a tort. So if you're walking on the sidewalk and slip on someone's driveway or something like that, you could sue them, and that would be a tort because you don't have a contract with that property owner. So this really, I think, is a great moment to ask you about the liability risks that universities face and how you manage, as a general counsel, the liability risk that a university faces, and why are there so many lawsuits against universities today? And are universities getting sued more often than they were in the past, or does it just seem that way from the outside in?
Great series of questions. Yeah, I mean, in terms of how you manage the risk, it's almost impossible. And I think when you think about modern colleges and universities, they're like little villages, right? So sometimes when I'm talking about this topic, and then if I'm giving a slideshow or something, I will put up a picture of a 19th century university. I have a favorite photo from our archives here at Hobart and William Smith, Hobart in 1860. And it's basically one brick building, and then you can kind of see the chapel over on the right, and there's a couple people just sitting in front of the building, like smoking pipes or whatever. But if you know our campus, you know that what's noticeably missing from it is the whole central administration building, right? Like there was just no need for it then. Longfellow has a description of the 19th century university as two or three large brick buildings, a chapel, and a president to pray in it. And I love combining that quote with the picture I just described, because it's almost exactly. And I'm sure if you went back into, looked at Cornell in the 19th century, you'd see a similar thing, just academic buildings. If you map out a modern campus today, the infrastructure, the labs, the playing fields, the parking lots, the equipment that's used to maintain campuses, just the technological infrastructure and all the whole host of cyber issues that come along with that. I mean, it's profound in its scope. So that's kind of what you're trying to manage risk for. And it's very difficult to do. And you just kind of have to take it kind of one issue at a time and one day at a time. I think another part of your question was around kind of are colleges and universities actually being sued more, or is it perception, or what's the data? We do have some data points to share on that. We know that there is a clear uptick in litigation against colleges and universities over the last, we looked at actually 120 years of case law. We had a research associate, thank you to Cornell Law School, look at Lexis and Westlaw, do a Lexis and Westlaw search for college or university for every year between 1900 and 2021. And what it produced is a chart that's basically like stable for about 70 years. And then all of a sudden just goes like this. And then in the last decade just goes almost straight up, right? So that tells us that litigation is up. And then, United Educators is an insurance company that insures most of the colleges and universities in the United States. They produce a ton of data around this question. And so looking at some of their data, it's clear that large damages awards against colleges and universities are up and over the past 10 years, and the actual amounts of those damages awards are up significantly. We also found some data that came from the Chronicle that showed job announcements for Office of General Counsel jobs over the last 10 years. And similarly, this is a pattern in all of our charts. It's just a strong upward to the right trajectory of jobs from 2010 to, I think they looked at, 2010 to about 2020, increasing year after year, more announcements for new hires. So yeah, we do think, and obviously, some of this may mirror other sectors, that's for sure, but I think some of it is very specific to higher education. And so what's causing it? There's a lot of speculation around that, right? I mean, obviously, the price of a college education is going up and up and up and up. And I think you used to hear about the infrastructure wars between colleges or the climbing wall. You got a new climbing wall, so we need to build a new climbing wall. I mean, I think that whole thing has sort of continued to escalate, and the price has gone up. And I mean, now you're talking about something that people are really investing significant dollars in for themselves or for their children or dependents or whomever. And so when you're in that kind of a position, if you suffer some real harm, you're gonna look to recover for that, right? So I think that price and cost drive some of it. I think also going into it is a phenomenon that's been kind of well studied and documented and worried about, which is public skepticism in higher education, right? So people saying, is it worth it to go to college, or am I better off being a plumber or pursuing, whatever other career path? So I think when people are more skeptical, they're more prone to sue. And then, I mean, there's obviously the talk of just society in general being more litigious, and whether that's real or not, you probably know more about that than me, but I think that's probably a factor going into it. Just anecdotally, and this is again part of the reason why we wrote the book, is just this feeling of over the last 10 to 15 years, it's more like almost on a daily basis there's an issue that requires a lawyer to kind of triage it and address it. And I know my peer institutions have felt that. There have been multiple 10 years ago, there were, I think, 2 NESCAC schools that had general counsel. Now nearly all do, except for, I think, 1. There have been several of my smaller peer liberal arts colleges in upstate New York that have added general counsel over the last 10 years. So, I mean, I think that, that's a reflection of something real that's happening. These schools don't just wake up one day and say, like, we want to add a new staff member for Z.
Yeah, no, absolutely. That's definitely a real phenomenon. So, Chris, let's get to our next poll question.
Yeah, you bet. Get your phones ready. Let's get those URLs going on in the browser and answer this question, please. What do you think is the most pressing issue or concern for general counsels in higher ed? Couple examples here: free speech, sexual assault, etc. So this is a word cloud type thing. Enter your text. Keep it brief, 1 or 2 words, please. And then we'll stand by for the results after this next question. So Dean Jens, back to you.
Great. Thanks so much, Chris. I'll look forward to hearing those or seeing those results. So a question from the audience from Paul, which is a great question. What kind of advice would you give to a university trustee who's trying to participate in, managing the, legal interests of the university and receiving advice from a general counsel? And for the sake of the question, assume that the trustee is not a lawyer.
Sure. I love that question. So one of the publications that I often get to contribute to is Trusteeship, which is an AGB, Association of Governing Boards, publication that they put out for trustees. And they have a legal standpoints column in that magazine that aims to help trustees, kind of guide trustees on how to interact with the legal function or what are the most pressing areas. I think kind of going to your core role as a fiduciary, really, it's having an awareness and understanding of what the most pressing issues are facing facing the sector broadly, but then also how your institution's particular issues may fit into those broader trend lines. So I think that's kind of a key way to interact with your legal counsel. Be asking, what do you think is going on out there in the world of higher education? What is going on with our specific legal issues, and how do they sort of map into that? And then I think it's just making sure you're kind of informed at the right level as a fiduciary, which is, you're floating at a 30,000-foot level. The old phrase is noses in, fingers out. I think that's fair, obviously, unless an issue directly involves a president or a senior staff member that has a kind of direct relationship with a board. I think that's a fair rule to stick to. But I think perusing headlines, I mean, it sounds kind of corny, but just making sure you have an awareness as a trustee of the headwinds that are facing the sector, from new legislation to litigation trends, and then just putting them by your institution's counsel and sort of saying, like, where do we land on this? I get that kind of stuff all the time, and I think it's helpful for me, and it's helpful for our trustees, because it lets me know what they're wondering about and what they're thinking. And if you see some coverage in the journal or whatever you read and you want to fling it to your counsel, I think that's a good idea.
Yeah, that's good advice. So I want to jump to the results of the poll right away, because I'm seeing some trickle in, and we've got a clear winner in terms of what's coming up more often, and that's free speech. I mean, a lot of the topics here obviously super relevant: diversity, equity, admissions, lots of different topics, academic freedom. But man, free speech is jumping out over and over again as a key area of interest. Any thoughts about free speech and how universities are confronting that topic?
Yeah, I mean, that is certainly the story of most of last academic year, I think, and this year. And it's really, when I've looked at this before, it was kind of surprising to me. Maybe it wouldn't be so much to others or to UDNs being familiar with higher ed, but these conversations have really been happening across the sector for a long time. I tend to just look in my own little bubble of the last few years, and certainly free speech has ballooned or mushroomed as an issue on campuses. But there were periods of this throughout the last half of the century, right? That where these issues kind of came to the fore, and certainly they also interact very importantly with academic freedom and the evolution of academic freedom as a professional norm in the early 20th century, and the institution of tenure as a means to kind of secure that academic freedom as well. So I think it continues to be an issue. It continues to be very unclear and murky and fact specific. I think, like what we saw last year were a lot of questions around expression via protest, right? And what were kind of the proper limits around protest on institutional campuses. So that was a big issue. And I think many schools over the summer took that as an opportunity to refine some of their demonstration policies and protest policies. But back specifically to speech, you see that in Title VI, right? Like what's protected speech and what is harassment. And I think that's kind of at the core of a lot of these debates that you see playing out or controversies. And, I think former President Shafiq of Columbia said it very accurately. She wrote an opinion piece for the Wall Street Journal before she testified in front of Congress. And I think, to paraphrase, she said that she thought institutions were being asked to do something that the Supreme Court had basically kind of danced around doing for the last 200 years, which is to really clearly define this line between free speech and harassment. And they're being asked to do it multiple times a day in multiple different fact patterns. And there's more to come on this topic. It's unclear where it's going, but it's not going away. I think that's fair to say. So
no, it's not. It's definitely not going away anytime soon. Do you find, in your experience, that courts and other institutions are, judicial institutions are, generally differential to the academic decisions that colleges and universities make, or is there kind of a lot of intervention into the decision making of the university?
Yeah, I love the term deference because I think there's sort of a technical legal application for the term, and then there's kind of just the general sense. And I think both are actually eroding for higher education in some pretty critical ways. There are still some. I think it's still fair to assume that in areas of academic specialty, courts are going to give some strong deference to institutions, right? So, like in a tenure case, for example, where an institution hasn't substantially deviated from their stated policies, where they've followed that contractual promise to the letter, at least in New York, that would be reviewed on an arbitrary and capricious standard. Courts are still deferential to institutions. Again, as long as there isn't a very clear kind of material breach of the contractual terms. So I think that's still very much alive. I think similarly in the admissions world, there's still a fair amount of deference to institutions, holding out the exception of I think I saw your eyes light up, but holding out, for exception, the area of when it comes to discrimination, right? So like I'm talking about if you're sort of what would be a run-of-the-mill case of like you find out that someone committed a crime and your policy said that you could revoke admissions and they wanted to sue you. I don't think they'd have a great case. I think the court would say, yeah, they're siding. It's up to the institution. They can decide. But in Students for Fair Admission, the recent affirmative action case, we saw the court completely sidestep, I think is the appropriate word. There are probably other words, but completely sidestep, sort of ignore Heisman, the question of deference to higher education, which was a key component of the prior decisions in this area. And in fact, prior to this decision, the Supreme Court said that institutions were entitled to deference on the question of whether diversity is a compelling interest that they want to pursue, right? So that has clearly eroded, and I think will continue to erode. And then I think there's deference in the sense or reduced kind of eroding deference in this the whole area of tort law, right? So where I kind of said before, where courts previously would be more likely to say like, you know what, they're an adult, they made a deal with you, and it is what it is. We're not going to allow this case to proceed. There are more and more cases surviving initial motions to dismiss where courts are like, you know what, yeah, you paid $300,000 for this educational experience and you've proffered some evidence that it might be the school's fault. We're going to let this case move forward. We'll see where it goes. I think fewer and fewer cases, and there's probably a better empirical way to prove this besides my anecdotes, and case law research, but I think fewer cases are just kind of being dismissed out of hand and more are being allowed to proceed on grounds that previously they may not have been able to proceed on. And then finally, one other case I just want to highlight is, look at the Gibson's Bakery Oberlin College case. I mean, I think that case is an example. It's a jury trial, right? But that's 9 or 12 people. I forget how large what the jury was in that case. But those jurors clearly, I think, had a view of higher education that was informing kind of the outcome and their verdict, right? So, and that speaks to this kind of diminishing deference and kind of trust, I guess, if you will, in higher ed. So I think, yeah, that's kind of how I would look at that.
Yeah, I mean, your comments about the affirmative action cases, I think, are really fascinating because you're right. The Supreme Court and the federal courts in general have kind of dropped this deference to higher education and universities when it comes to diversity issues. But strangely enough, federal courts have always had a kind of deference to the military on national security questions and to the executive branch in general. And those two things are colliding a little bit because in those decisions, on the affirmative action case, the courts explicitly said, well, we're not going to touch the question of affirmative action at the military service academies like West Point, because those are a little bit different because I think they're leaving open the possibility of saying, actually, we're not going to tell the Defense Department, how important diversity is to running a modern army. They might say that, and they're clearly leaving open that question. But they are willing to tell Harvard whether or not diversity is important for enrolling a college class and how they should go about ensuring diversity and what way is inappropriate. But they're not going to grant the same level of deference possibly to a military service academy. But we'll see. We'll see how that plays out. All right. We only have a few minutes left, but I really want to know, like, how are you sort of assessing the future? Like, are there topics here that are really keeping you up at night? Like, what do you think are like the big challenges for legal education? Not today and not, last year, but like 2 years from now, 3 years from now. What worries you about, the challenges that you're going to confront as a general counsel or your institution or your president or your board of trustees? Like, what are you worried about in terms of the future problems that are around the corner?
Yeah, that's a great question. I mean, these things are always kind of funny, and I'm supposed to say things like artificial intelligence or climate change or whatever, and and those are like, I think those are real, honestly, and I mean, and they will present nuanced challenges. But then, there was also this great piece by Adam Grant recently, you probably saw, that was like, the headline was almost all you needed to read, was basically like, if you think you can predict the future, think again, you're wrong. About kind of what's coming in terms of regulatory shifts down the road. And I think that's probably most accurate. I do worry a little bit about the compounding nature of all of this stuff and the effect it will have across the sector. I talked about adding staff and costs, and I do think that, I don't think it's going away, and I don't think it's getting better. And I think that as institutions become more strapped with a demographic cliff, or as more and more institutions kind of get closer to questioning their existence, I think it's going to be harder for them to also deal with and weather all of these issues. So that's not something I particularly am worried about in my specific seat, but it's something that, as a general counsel, I think across the sector, it's just the whole thing is going to kind of mushroom. I don't want to make any predictions about kind of the potential regulatory changes ahead. I guess I'll make a couple small ones. I mean, I'm pretty sure that Title IX will revert back to, there was a prior regulatory structure in place under the now incoming administration. So I can only assume that will revert back. I can't imagine that Title VI kind of strategy would get walked back in any significant way. And I wonder a bit about expansion of some of the reasoning of the court in Students for Fair Admission. So I think that's a possibility. And then I wonder about accreditation and if regulators in the future will look more kind of put a little more scrutiny into accreditors and into how they're interacting with institutions as a means of kind of shaping private education. So, those are some things, but it's not, I don't have one particular kind of werewolf that keeps me up. It's really the compounding of all this stuff, and it's how it's going to kind of balloon and mushroom and keep doing so.
Yeah, obviously lots of challenges, and things are going to get more complex rather than less complex. So we only have about 3 or 4 minutes left. I was wondering if you could talk a little bit about what the risks of compliance issue are. I mean, I think it all seems a little bit obscure, not just to outsiders, but even to faculty and staff, and certainly to students. So there are all of these, federal regulations, there are all these state regulations. The university has to comply with them, but it's not like a private lawsuit for money damages. Like, you're not going to get sued from, a plaintiff's attorney. It's the government that's saying you have to comply with all of these things. What's really at risk for the university? Like, is it a big deal if a university just kind of, doesn't do a good job of complying with federal regulations, or willfully, disobeys them? Like, what's the consequence for a university?
No, I think it is a big deal. I mean, I think, well, with some of these statutes, I mean, Title IX and Title VI, there are private rights of action. So you can be sued, right? Any damages in court. And I think that's a very real risk for many. And I mean, just under Title VI last year, there's two very interesting and divergent decisions, one against MIT and one relating to MIT and one relating to Harvard, that I think are worth a look in that area. So I think like, outside of kind of the money damages courts remedies, yeah, the loss of federal funds, the potential to lose federal funds is significant for many institutions, even for small ones that are less, research focused like my own. So I think there's that, but then there's also just kind of the sheer embarrassment, right? Of if that were to happen, aside from it actually happening and the financial ramifications. But then there's a cost, if you will, to the whole investigation and resolution process. Like even if you don't end up, and many schools do not end up losing federal funds or have not yet, right? But there is a very real and serious cost to that whole process, right? Whether it's not just in attorney time, but in, deans of schools time or faculty members time or other administrators time in managing and dealing with all this stuff. So being under federal investigation is not just the investigation itself can be,
Yeah, no, absolutely. And being subject to an audit from a federal agency, I mean, for a small college, that could be an annoyance. For a large university, an audit from the Department of Education on some compliance issue you have to hire not just attorneys, but also auditors. And that could cost the university actually millions of dollars over many years to deal with that. So it's no fun at all. I don't recommend it. Well, Chris, let me turn it over to you to take us out.
Thank you, Dean Jens, and thank you, Lou Gard, for joining today's show. Listeners, check out the episode notes for info on the Master of Science in Legal Studies degree program at Cornell Law, and also a link to Lou Gard's book. Thank you again, friends, and please subscribe to stay in touch.